Do you know what a preliminary examination is? I'm attorney Keith Whiddon, and I'm a criminal defense lawyer in Monroe, Louisiana, and in less than 5 minutes, I'm going to tell you what a preliminary examination is, why it's important, whether or not you can even have one in your criminal case. First of all, a preliminary examination is the chance for you, or even the state, because the district attorney can ask for a preliminary examination, have probable cause, or if the officer had probable cause at the time of the arrest for you to actually be arrested for the charges that you were taken to jail on. How does this happen? Well, your defense lawyer is typically going to file a motion for preliminary examination, and the judge is going to set a date for that to occur. The DA's office is going to bring witnesses, and you can also bring your own witnesses, even under the power of a subpoena if needed, so that those people can testify on your behalf. The judge is going to listen to testimony, whether it be from the officer, other witnesses, your witnesses, lab technicians, your neighbors, whoever may have relevant evidence in this case. And that judge will make a determination of whether or not the officer had probable cause to arrest you for the charges that he or she arrested you for. Why is this important? Because if the judge finds that there was no probable cause, that means that whether it be for one charge, 3 charges, all charges, whatever charge the judge finds there is no probable cause, you now no longer have a bond obligation. You no longer have to make bond to get out of jail on that charge when the judge finds there is no probable cause. So you can go from having, again, $100,000 or even $1 million bond down to 0 if the judge finds there is no probable cause for the charge. Going a step further, it is not uncommon for preliminary examinations to be held at the same time as a bond reduction hearing. And because the judge is hearing all of this evidence, he may find that there was probable cause, but still may lower your bond if you have also filed a motion for a bond reduction in your case. Finally, do you even get a preliminary examination for your case? So, let's answer this question. Number 1, if you have been arrested for a felony, you are entitled to that preliminary examination. If you are arrested for a misdemeanor, you don't get a preliminary examination. It is not in the Louisiana Criminal Code. Now, there is one caveat, one very important factor when it comes to your preliminary examination and whether or not you get one. If you are charged with a crime that you are to be indicted for, example of this would be murder. Murder is a crime that you must be indicted for by Louisiana law. If you are facing an indictment, you are allowed or entitled to a preliminary examination before the bill of indictment is filed. But the moment the state files the bill of indictment, you are no longer entitled to your preliminary examination. So, if you have an indictable crime, but you have not been indicted yet, you need to make sure that your lawyer files that motion for preliminary examination and has it set as soon as possible in your case.